Today is the first Monday in October. It's the date that marks the start of a new term for the United States Supreme Court. All indications are this term will be of major consequence. The court has chosen to take up a number of cases that have the potential to dramatically change America as we know it. For example, the court has decided to hear cases in which it is being asked to overturn Roe v. Wade, as well as strike down state laws regarding the carrying of weapons in public places. These are among the momentous issues on the court's first term. Madam President, I will yield the floor to the leader. And he's asked me to carry on for a little bit here. Back to my statement, these are among the momentous decisions the court's merits, issues on the court's merits dockets this term. But the court has been also very active on another docket, the shadow docket. For most people are not familiar with that term, don't know what it means. We learned in the Senate Judiciary Committee. It refers to decisions issued by the Supreme Court outside of the regular routine merits docket. These decisions are often rendered on a very short timetable without full briefing, public deliberation, detailed explanation, or signed opinions. Historically, shadow docket orders were mostly non-controversial. They typically involve routine or procedural questions, such as establishing deadlines for parties to file briefs. But that has changed in recent years. Not only have the orders from the Supreme Court's shadow docket become more substantive and controversial, they've also been taking an increasingly clear ideological bent. Consider the weeks leading up to the start of this new October term. The court's conservative majority used the shadow docket to block the Biden administration's COVID eviction moratorium and to reinstate the Trump administration's cruel remain in Mexico policy that unfortunately blocked families and children fleeing persecution. The court's majority also used the shadow docket last month to allow Texas law SB 8 to take effect, a law that effectively bans abortion after 6 weeks, directly violating the constitutional protections of a half a century from Roe v. Wade. These and other shadow dockets from the court's conservative justice are having a profound consequence for millions of Americans. Last week, the Senate Judiciary Committee, which I chair and the presiding officer has joined as a member, held a hearing on the court's use of the shadow docket. We heard from a number of experts about the increased use of the docket and the increasing ideological nature of its use. They pointed out, for example, that President Trump's Justice Department, 4 years, requested the court take emergency action on the shadow docket a record-breaking 36 times in 4 years. The court granted 28 of those requests. What about previous presidents? In contrast, the Justice Department only requested emergency relief 8 times, total 8 times in 16 years of George Bush and Barack Obama. And on only 4 occasions was the shadow docket approved. The request was approved. At this point, I'm going to yield the floor and ask consent that when I return to the floor, I be able to resume these remarks, but I want to yield to the majority leader.
Objection.